the first thing I want to say about it is that, you know, the practice of law, for those of us that are litigators and we try cases, every day, in every courtroom in America, lawyers are fighting over facts, what the law is, what the law should say, what the law should be, what case law is. That gets fought over all the time. That's part of the law practice. Rarely do you see people getting disciplined for having a different idea about what the law is or for what they've said. That largely is what underlies this case. Now, I handed out my own press packets that I will address here, what that means, what the context of it is. In May 2015, we filed our appeal brief in the Kline appeal. That same day, we filed a motion to recuse some of the justices of the Kansas Supreme Court, specifically Justice Carol Beyer, for the opinions she had written in Kline-related litigation that were just nasty and inaccurate. And we also filed to recuse Chief Justice Nuss for different reasons that were unrelated to the abortion cases. 3 days after we filed that motion, 5 of the justices of the Supreme Court recused themselves from the Kline appeal. We were quite blown away by that, but we thought it was justified and probably the right thing to do. The primary, there's 10 claims in the federal complaint that we filed today. The first 3 relate to an issue in the Kansas Constitution that is fascinating and quite serious as to the integrity of the Supreme Court decision that suspended Phill Kline's law license. The handout that I gave you, give me a minute. What happened in Phill Kline's case was unprecedented because suddenly 5 of the 7 justices were gone. And a press release came out from the press office of the Kansas Supreme Court saying that Justice Biles, one of the 2 remaining justices, would be the presiding judge and that he would make appointments to fill the vacancies, the temporary vacancies created by the 5 recusals. That's a big problem. Article 3, Section 2 of the Kansas Supreme Court says in part, all cases shall be heard with not fewer than 4 justices sitting, and the concurrence of a majority of the justices sitting, and not fewer than 4 justices shall be necessary for a decision. In this case, only 2 justices were sitting for the case. Our position is that the body of jurists, and notice I don't call it the Kansas Supreme Court. In the complaint, we refer to it as the post-recusal court. It is not the Kansas Supreme Court. Our position is it was not a court at all. It was a group of jurists cobbled together by Justice Biles and maybe someone else making that decision with him to fill the seats that had been vacated by 5 recusals. We have at least 5 or 6 cases that we researched where the Kansas Supreme Court, there was 1 recusal or an empty seat for some reason, and the remaining 6 justices split 3-3 on their vote. And they said in those cases, we can't change the decision below, first because we're split 3-3, but second because we must have 4 justices to vote for the majority for any decision. So we think this is a grave constitutional problem that we were not aware of when we filed our appeal brief. We didn't research it in depth until after the decision came down. But we believe that the decision of the Kansas Supreme Court suspending Phill Kline's law license is void. It's a legal nullity. Now, what does that mean? What does that mean for federal court? Because, as you probably know, to be in federal court, you need a issue of federal law. And our research tells us that it is a violation of procedural due process under the 5th and 14th Amendments to the U.S. Constitution taken from you without a properly constituted tribunal. And a court sitting in Kansas in that building with 2 justices and 5 replacement judges from lower courts is not a properly constituted tribunal. The judgment's void. Phill Kline's law license was never suspended. That's what a void judgment is. It never had any effect from the beginning. He still has his license. People just don't know it. Now here's the problem. Here's the problem. In February 2014, we filed a motion with the Kansas Supreme Court called a motion to vacate the judgment. And in that motion, we asked them to address this very issue and to acknowledge that the judgment is void. That motion was mailed back to us. Carol Green, the clerk of the appellate court, a very nice lady to deal with, just mailed the motion back with a letter that said, sorry, the case is over. We're not taking any more motions. Now there's a big problem with that. First, the due process of the Constitution gives us the right to be heard. We filed a motion to be heard on the crucial issue of whether we even had a proper court suspending his law license. The court wouldn't even docket the motion. It was mailed back to us. So if the Kansas Supreme Court's not going to hear it, who is going to hear it? We have a right to be heard. Mr. Kline has a right to a properly constituted tribunal. It violated his due process rights not to have that. That is one of the central reasons why we filed a lawsuit in court today for declaration by the federal court that the suspension of his law license is void. A related issue is that Justice Biles, under the Kansas Constitution, which is the second page of what I gave to you, it gives the Supreme Court authority to fill temporary vacancies when a justice has to recuse, or sometimes death, whatever, with empty the seat. The Supreme Court is given authority to fill vacancies. An individual justice does not have the authority to fill vacancies. And that's important, and it's easily argued right from the Constitution, because the subsection right before, it's Article 3, Section 6F, gives the Supreme Court authority to assign a district court judge to serve temporarily on the Supreme Court. The section right before that, Article 3, Section 6E, says that the Supreme Court or any justice thereof has the power to assign a district court to another district. So those that wrote the Constitution knew very well the difference between the Supreme Court and a justice thereof, because within one section they make the distinction. So aside from the fact that there weren't 4 justices sitting, the appointments by Justice Biles were also invalid. 2 different reasons the court was invalidly composed. Now, beyond that, we make various arguments in the federal complaint about what we consider just outrageously arbitrary findings by the post-recusal court, distorting the record, imputing to Mr. Kline things that he didn't say, punishing him for things he didn't say, changing rules, rewriting rules to mean what they didn't say. This kind of arbitrariness from the high court of a state, many times you can't do anything about it. They're the final word. But at some point, when it gets bad enough, it violates due process. Just have arbitrary, willy-nilly decision-making coming from a high court. And we've asked the federal court to look at that to see if the arbitrariness of that decision was so bad that it violates federal due process. Another thing we've asked the federal court to do in the complaint we filed today is to find that there's been a violation of the Equal Protection Clause. Because what we found in this case, these are made for Kline disciplinary standards, applied to no one else. The complaint lists 3 pages of bullet points of conduct of the Supreme Court justices, of the replacement judges, of Stan Haslett, the disciplinary administrator, of the lawyers on the panel that recommended Mr. Kline discipline. The dishonesties, the distortions of the record, the violations of the rules. Mr. Peckham referred to it. It is a fundamental thing in disciplinary cases that there's a probable cause, there's an independent probable cause finding in Kansas by a review board They have to give it their blessing that there's probable cause, and then Mr. Hazlitt gets to go file a complaint. There was no probable cause finding, and apparently that's fairly routine here. The people breaking the rules, the people telling the lies, are the ones who suspended Phill Kline for alleged rule breaking and lying. It's an outrage. The federal courts need to look at this, and we're going to press it on to the very end. Now, the complaint says more, but we've gone on a bit. Some of you, I'm sure, have questions. I'll be happy to answer them before I go on to the next phase of my presentation.